Good day. To formally start our video presentation, on behalf of our group, please allow me to introduce first our topic, which is all about the intellectual property and the copyright. But right now, let us define first what is an IP or the intellectual property really means. From the word itself, intellectual, these are created by the use of our human intellect. Another term, we can now call it as an intangible, right? These are things that cannot be physically touched. While the property, these are something that is owned by someone. Another term, we can now call it as an asset. And when we combine this term, the intellectual and the property, we can now conclude that these are the set of intangible assets, which are created by our minds, such as inventions, literary and artistic works, designs and symbols used in commerce. IP is protected by laws such as patents, copyright and trademarks, which allow creators to earn recognition for financial benefits from their creations. It encompasses a wide range of activities and plays a crucial role in both cultural and economic life. Companies are diligent when it comes to identifying and protecting intellectual property because it holds such high value in today's increasingly knowledge-based economy. So, it can also be represented as a competitive advantage, and as a result, it is firstly guarded and protected by the companies that own the property.
Good day everyone, I am Raya P. Nojales, the first reporter, and the topic I will discuss to you will be about the basics of intellectual property rights and intellectual property and online research. So let's delve into basics of intellectual property rights. Intellectual property or IP rights refer to the legal protections granted to individuals or entities for their creations or inventions. There are several types of IP rights, including patents, trademarks, copyrights, and trade secrets. So what exactly is patents? Patents protect new inventions and provide exclusive rights to the inventor for a limited period. This allows them to prevent others from using or selling their invention without permission. Patents are like a protective shield for new inventions. They give the inventor exclusive rights to use, make, or sell their invention for a certain period. It's like saying, "This is my invention, and nobody else can use it without my permission." So next is trademarks. Trademarks protect brand names, logos, and symbols that distinguish goods or services from others in the market. They help consumers identify and differentiate between products or services of different companies. These are unique symbols, logos, or brand names that represent a company's products or services. They're like a company's identity in the market. They help customers distinguish one company's product from another's. Next is the copyrights. It protects original works of authorship, such as books, music, paintings, and software. They grant the creator exclusive rights to reproduce, distribute, display, and perform their work. Copyright is like thinking of this as a creator's best friend. They protect original works like books, music, or software. The creator gets exclusive rights to use, share, display, or perform their work. It's like saying, "This is my creation, and you need my permission to use it." Next is the trade secrets. Trade secrets refer to confidential information that gives a business a competitive advantage. This can include formulas, processes, customers' lists, and other valuable information that is publicly known. These are a company's secret sauce. They're confidential pieces of information that give a business an edge over its competitors. This could be a secret recipe, a unique process, or a valuable customer list. It's like a hidden treasure that a company protects fiercely. Remember, all these IP rights are legally protected. It means that if someone infringes on these rights, the owner can take legal action against them. But also, these rights come with responsibilities and limitations. For instance, they're usually protected for a limited time, and sometimes they may not prevent others from creating similar things. So, understanding these rights thoroughly is crucial for anyone wanting to protect their creations or inventions. So, the next topic we were going to delve in is all about intellectual property and online research. With the advent of the internet, conducting research online has become common practice. However, it is important to be aware of intellectual property issues when using online sources. Fair use. Fair use is a legal doctrine that allows limited use of copyrighted material without permission from the copyright owner. It is typically applicable for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. However, the determination of fair use can be subjective and depends on factors such as the purpose and nature of the use, the amount and substantiality of the portion used, and the effect on the market for the original work. So, fair use is like a get-out-of-jail-free card for using someone else's copyrighted work. It allows you to use small portions of the work for specific purposes like teaching, reporting, or research. But remember, what counts as fair use can be a bit fuzzy and depends on various factors. It's not a free pass to use copyrighted work as you please. Next is plagiarism. Plagiarism is the act of using someone else's work or ideas without giving proper credit. When conducting online research, it is important to properly cite and attribute any sources used to avoid plagiarism. Plagiarism is a big no-no in the world of intellectual property. It's like stealing someone else's work or ideas and passing them off as your own. So when you're doing research online, always make sure to give credit where it's due to avoid plagiarism. Next is licensing. Many online resources such as images, music, and software are protected by copyright. To use these resources legally, you may need to obtain a license from the copyright owner. Licenses can specify the terms and conditions of use, including whether it is for personal or commercial purposes. So when we talk about licensing, we will think of this as a ticket to legally use someone else's copyrighted work, like images, music, or software. You might need to get a license from the copyright owner, which will spell out how and where you can use their work. It could be for personal use, commercial use, or both. So, when you are doing research online, always be mindful of this intellectual property rules there to protect the rights of creators and to ensure that their work is used fairly and responsibly. So, that would be all for my topic. The next discussion will be made by the next reporter.
To continue the discussion of our first reporter, let us discuss the third one, which is all about the copyright basics and the copyright issues in online research. But before that, let us define what is the copyright. Copyright is a form of intellectual property that protects original works of authorship. It grants exclusive rights to the creator, allowing them to control how their work is used and distributed. Works are original when they are independently created by a human author and have a minimal degree of creativity. Independent creation simply means that you create it yourself without copying. But when we say copyright basics, copyright automatically applies to original works of authorship once they are fixed in a tangible form, such as writing, recording, or painting. It provides the creator with exclusive rights, including the right to reproduce, distribute, display, and perform the work. Copyright protection generally lasts for the creator's lifetime, plus a certain number of years. In order to understand the importance of copyright and how to protect it, it is important to examine the basics of copyright law. What it is, what it protects, and how to secure it. The primary purpose behind copyright law is to foster the creation and dissemination of works for the benefit of the public. Next, let us talk about the copyright issues in online research. When conducting online research, it is important to be mindful of copyright issues. This includes using copyrighted materials within the bounds of fair use, properly attributing sources, and seeking permission or licenses when necessary. It is also important to be cautious of infringement, which can occur when using or sharing copyrighted materials without authorization. So that's why it is also important to note that copyright protection is not limited to the final, published form of a work. Drafts, preprints, and unpublished research also enjoy copyright protection. Fair use and other limitations of copyright. Under certain circumstances, even copyrighted works can be reused. Copyright law includes certain limitations and exceptions. First, we have here that certain activities are explicitly permitted by copyright law. So if we want society as a whole to benefit from new ideas and information, and so copyright protection is limited. Copyright may expire after a certain period of time, and the law allows certain limited uses of copyrighted materials by others without the creator's permission. So the most important such use is fair use, which will be tackled later on. Second, other activities may be permissible if they meet guidelines established by copyright law. Copyright protects only the form in which ideas or facts are expressed. It does not protect ideas or facts themselves. Like for example, you may read a copyrighted article and appropriate its ideas or the facts. It conveys it into your own work without violating the copyright. However, unless fair use or another exception to copyright protection applies, you may not reproduce the actual text of the paper without the permission. In our next topic, let us talk about the 4 factors of fair use. But before that, let us define first what is the fair use. Fair use is a branch of copyright law relating to the reuse and reproduction of copyrighted material. Like all matters related to copyright law, fair use is a complex topic with lots of ins and outs. For a work to be considered fair use, it must meet a number of conditions. The 4 main determining factors are the following. Now let's dig into each of these key determining factors, starting out with the purpose and character of the nature. The purpose and the character of the use, which is arguably the most important of the bunch. Like for example, for a piece of content to be protected by fair use, it must be transformative in nature. This means that a video which alters, edits, and comments upon a copyrighted work into something new, whereas simply uploading a movie or an unedited clip from a movie would not be protected by the fair use because it is not transformative in nature to simply reproduce a copyrighted work verbatim. Second is the nature of the copyrighted work. This determining factor is the most straightforward of the core 4. Like for example, one nature of the copyrighted work instance that might not be acceptable for fair use could be portions of an incomplete feature film that has yet to be publicly released. And the third one is the amount of substantiality of the work. This factor is key in determining whether or not a piece of content will or won't be protected by fair use copyright law. But it is often misinterpreted, so allow us to dispel the confusion. Some misinterpret the amount and substantiality determining factor to mean that only short snippets of copyrighted material may be used in a fair use work, but this isn't accurate. By the letter of the law, one could include the entirety of the copyrighted work within their own material if each and every aspect of the copyrighted work is integral to the new work and commented upon or repurposed. Fourth is the potential market effect. To put it in simple terms, this determining factor looks at whether or not the fair use project has a substantial negative effect on the success or audience of the original copyrighted material. Determining fair use evaluator and the fair use index. When we say fair use evaluator, tool from the American Library Association to help you determine whether a particular use is likely to be considered fair. Whereas the Fair Use Index is a searchable database of court cases about fair use from the U.S. Copyright Center for the purpose of helping lawyers and the public better understand how fair use has been interpreted.
What is Creative Commons? Creative Commons makes it possible to freely share intellectual property on a large scale. Creative Commons refers to a set of intellectual property licenses and the organization behind those licenses. So, Creative Commons is like a friendly middleman in the world of copyrights. It helps creators share their work but still have the control over how others use it. So it's a set of rules that say, hey, you can use my work, but here's how you can do it. So it makes sharing ideas and creativity easier and fairer to everyone. So each Creative Commons license consists of 3 layers. So first is the legal code, Commons Deed, and the machine-readable language. So it's like having a clear set of rules for sharing creative work, making it easier for people to understand and use while still respecting the rights of the creators. Protecting business assets online. So, protecting your business assets is essential for the long-term success and sustainability of your company. By implementing strategies to safeguard your assets, you can minimize the risks posed by various threats and ensure the smooth functioning of your operations. So, protecting your business assets online is like building a fortress for your valuable digital resources. It involves implementing strong security measures, educating employees about cybersecurity, and staying vigilant against cyber threats. So, by safeguarding your assets, you can keep your business safe, maintain customer trust, and preserve the integrity of your online presence.
Good day everyone, I am Janet B. Mapoto and my topics is digital privacy and counterfeit goods. Digital privacy and counterfeit goods are two interconnected topics in the digital era. If we say digital piracy, it involves the illegal copying or distribution of copyrighted material online, impacting the creative industries and posing economic and security risk to consumers. Pirate operator sites generate revenue through advertising, donations, subscriptions, selling user data, and affiliate marketing. Buying content from these sites deprives the industry of revenue, hindering the creation of new content and jobs. While counterfeiting of goods, it refers to the production and distribution of goods that violate intellectual property rights. Counterfeit goods are produced to save costs and often have lower quality materials and exploit illegal labor. Counterfeiting has become a transnational issue with economic and social consequences, facilitated by globalization, the internet, and the transfer of knowledge and technology. That would be all. Thank you.
Good day everyone, I'm the next reporter. My topic is about Digital Millennium Copyright Act or DMCA and the Digital Rights Management or DRM. The Digital Millennium Copyright Act is a United States copyright law that criminalizes the production and dissemination of technology, devices, or service intended to circumvent measures that control access to copyright works. It also criminalizes the act of circumventing an access control, whether or not there is actual infringement of copyright itself. The DMCA or Digital Millennium Act has been a subject of controversy, with some arguing that it stifles innovation and restricts fair use, while others argue that it is necessary to protect intellectual property rights in the digital age. An example of DMCA is inaction is when a website receives a takedown notice for hosting copyrighted material without permission. Let's say a user uploads a video that contains copyright music to a popular video sharing platform. The copyright holders discovers this unauthorized use and submits a DMCA takedown notice to the platform. Upon receiving the notice, the platform is legally obligated to remove the infringing content to avoid liability under the DMCA. The next topic is about digital rights management. The Digital Rights Management, or DRM, refers to the technologies and techniques used by copyright holders to control access to and uses of digital content and devices. DRM systems are designed to prevent unauthorized use and distribution of digital media and restrict the ways consumers can copy content they purchase. Critics of DRM, or Digital Rights Management, argue that it can be overly restrictive and the limit of the rights of consumers, while proponents argue that it is necessary to protect the rights of content creators and prevent privacy. That's all. Thank you.
The international perspective on intellectual property. First, the concept of intellectual property rights in the public domain is not only relevant within a single country or region, but also holds significance on an international scale. Different countries have varying perspectives and approaches towards intellectual property rights, which influences the availability and accessibility of creative works in the public domain. Second, one example of an international perspective on intellectual property rights is the concept of fair use in the United States. Fair use allows for the limited use of copyright material without permission from the copyright holder under certain circumstances, such as criticism, comment, news reporting, teacher, scholarships, or research. Third, on the other hand, some countries have a more restrictive approach to intellectual property rights, emphasizing the protection of creators' rights over public accesses. For instance, in China, copyright laws are often enforced more strictly, and the public domain may be limited as a result. The international perspective on intellectual property rights and the public domain is not limited to legal frameworks alone. Cultural attitudes and societal norms also play a significant role in shaping these perspectives. For example, in some indigenous communities, the concept of intellectual property differs from the Western notion, as knowledge
Good day everyone, my name is Randall Suligan and my topic for today is all about ethical use of intellectual property and legal consequences of ID validation, the ethical and legal implications of information systems. Information systems ethics. The introduction of new technology can have a profound effect on human behavior. New technologies give us capabilities that we did not have before, which in turn create environments and situations that have not been specifically addressed in ethical terms. Those who master new technologies gain new power. Those who do not master them may lose power. Implemented the first moving assembly line to create his Model T cars. While this was a great step forward technologically and economically, the assembly line reduced the value of human beings in the production process. The development of the atomic bomb concentrated unimaginable power in the hands of one government, who then to wrestle with the decision to use it. Today's digital technologies have created new categories of ethical dilemmas. For example, the ability to anonymously make perfect copies of digital music has tempted many music fans to download copyrighted music for their own use without making payment to the music owner. Many of these who would never have into a music store and stolen a CD find themselves with dozens of illegally downloaded albums. Code of ethics. One method of navigating new ethical waters and a code of ethics. A code of ethics is a document that outlines a set of acceptable behaviors for a professional or social group. Generally, it is agreed to by all members of the group. The document details different actions that are considered appropriate and inappropriate. A good example of a code of ethics is the Code of Ethics and Professional Conduct of Association for Computing. Includes academics, researchers, and practitioners. Here is a quote from the preamble. Commitment to ethical professional conduct and expected of every member, voting members, associate members, and student members of the Association for Computing Machinery or ACM. Sidebar, acceptable use policies. Many organizations that provide technology service to a group of constituents or the public require agreement to an acceptable use policy or EUP before those services can be accessed. Similar to a code of ethics, this policy outlines that is allowed and what is not allowed. While someone is using the everyday example of this is the terms of service that must be agreed to before using the public Wi-Fi at Starbucks, McDonald's, or even in a university. Here is an example of an acceptable use policy from Virginia Technology. Intellectual property. One of the domains that have been deeply impacted by digital technologies is the domain of intellectual property. Digital technologies have driven a rise in new intellectual property claims and made it much more difficult to defend intellectual property. Intellectual property is defined as property as an idea, invention, or process that derives from the work of the mind. This could include creations such as song lyrics, a computer program, a new type of toaster, or even a sculpture. Practically speaking, it is very difficult to protect an idea. Instead, intellectual property laws are written to protect the tangible results of an idea. In other words, just coming up with a song in your head is not protected, but if you write it down, it can be protected. Copyright. Copyright is the protection given to songs, computer programs, books, and other creative works. Any work that has an author can be copyrighted. Under the terms of copyright, the author of a work controls what can be done with the work, including who can make copies of the work, who can make derivative works from the original work, who can perform the work publicly, who can display the work publicly, who can distribute the work. Many times, a work not owned by an individual but it is instead owned by a publisher with whom the original author has an agreement. In return for the rights to the work, the publisher will market and distribute the work and then pay the original author a portion of the proceeds. Copyright protection lasts for the life of the original author plus 70 years. In the case of the copyrighted work owned by a publisher or another third party, the protection lasts for 95 years from the original creation date for works created before 1978. The protections vary slightly. You can see the full details and copyright protections by reviewing the Copyright Basics document available on the U.S. Copyright Office website. Obtaining copyright protection. In the United States, a copyright is obtained by the simple act of creating the original work. In other words, when an author writes down the song, makes that film, designs that program, he or she automatically has the copyright. However, for a work that will be used commercially, it is advisable to register for a copyright with the U.S. Copyright Office. A registered copyright is needed in order to bring legal action against someone who has used a work without permission. First sale doctrine. If an artist creates a painting and sells it to a collector who then, for whatever reason, proceeds to destroy it, does the original artist have any recourse? What if the collector, instead of destroying it, begins making the copies of it and sells them? Is this allowed? The first sale doctrine is a part of copyright law that addresses this as shown below. So, an example. The copyright owner has no recourse if the collector destroys her artwork, but the collector does not have the right to make copies of the artwork. Fair use. Another important provision within copyright law is that of fair use. Fair use is a limitation in copyright law that allows for the use of protected works without prior authorization in specific cases. For example, if a teacher wanted to discuss a current event in her class, she could pass out copies of copyrighted news story to her students without first getting permission. Fair use is also what allows a student to quote a small portion of a copyrighted work in a research paper. Unfortunately, the specific guidelines for what is considered fair use and what constitutes copyright violation are not well defined. Fair use is a well-known and respected concept and will only be challenged when copyright holders feel that the integrity or market value of their work is being threatened. So that's all for today, and thank you.